Very pleased to welcome to the show Peggy Little, Senior Litigation Counsel for the New Civil Liberties Alliance. And they are involved in the case of Cochran versus SEC. And this is super nerdy constitutional law stuff that I love, and I hope you will love it too. Peggy, welcome to the show.
Thank you very much for having me, Ray.
That long introduction that I just did I say anything that struck you as wrong?
No, not at all. The administrative law judging is a serious problem in this country. Most people don't realize this, but people are 10 times more likely to be hauled before an administrative law judge than they are to be brought before a real judge in a federal court, which affords them constitutional, evidentiary, and due process protections that you do not have before an administrative law judge.
What is an administrative law judge?
The biggest problem with an administrative law judge, and there are many, but the biggest one is that he is employed by your prosecutor.
So give us an example. Actually, you could give us the example in this case, because it's a perfect example of what that looks like.
Sure. Michelle Cochran, who is a CPA in Texas, and she was charged by the SEC with a paperwork violation and brought before a judge who is employed by the SEC. And that judge, her first judge, would routinely tell people he had never ruled against the agency. So the structural biases of these judges is a serious problem. The fact that they cannot be removed and they're not subject to presidential control is the issue in Michelle Cochran's case right now. But there are numerous due process problems with administrative law judging as well. And finally, one of the briefs that NCLA filed in the Supreme Court also pointed out that these judges have no expertise. Michelle's first judge came from the Social Security Administration and knew nothing about securities law when he was appointed.
Wow. So I actually would have thought that the ALJ, in a case being brought by the SEC, would have come from the SEC. And are you saying they can, but they don't have to necessarily?
No. There's a pool of administrative law judges. Most of them are in the Social Security Administration, so they're used to either granting or denying benefits. There's a lot in the Veterans Administration, but the other agencies draw from that pool of judges to appoint their judges. And so even though one of the defenses of administrative law judging is you have supposed experts, we found in looking in the background of all of these judges, and there are 5 judges at the SEC, that none of them have a background in securities law. So as we like to say, expertise emperor has no clothes.
So, okay, that's already pretty damning. I'm wondering whether the SEC gets to choose the judge, or whether, like 3-judge panels on courts of appeal, the judges are chosen randomly.
Well, no, what the SEC gets to choose is, in all of these cases, it could take you to federal court. And we think that is the best and only way they should be able to try Americans, because that is in a separate branch of government. A federal judge is not employed by the SEC. A federal judge will give you due process, evidentiary, and procedural protections. But as our amicus briefs in Michelle Cochran's case show, when you go to the administrative proceeding, first of all, your judge is employed by your prosecutor. Second of all, you have a very short time in which to prepare your defense, even though the SEC has had years, usually, of pre-enforcement investigation. They tie you up for as long as 6, 8, 10 years in these proceedings, and you are not able to get the constitutional problems with these systems before a real judge until after you've completed the proceedings, one of our briefs on behalf of Ray Lucia, George Jarkissi, and Christopher Gibson shows that in their cases, they had to wait for nearly a decade before they could go to an appellate court to say that their proceeding wasn't constitutional to begin with. And guess what happens when you win? They send you back to do it all over again.
Unbelievable. It's just, I want folks to just think about whether this feels like justice, that a federal agency, who many of us think are already over-aggressive on so much stuff, they can claim that you violated a law, or they can even claim that they violated a rule that they made up that was never passed by Congress, and then they will put you in front of and I'm putting this in air quotes now, judge, who is another government bureaucrat from another federal agency who probably, by the way, doesn't want to be on the wrong side of the federal agency that he's performing this function for, like the Social Security guy, probably wants to side with the SEC in case he ends up being the prosecutor, quote-unquote prosecutor, in a Social Security case against somebody and gets an ALJ from the SEC. The whole thing is just so... I don't know if corrupt is the right word, but it's close to corrupt, at least.
It is. I should clarify that even though they draw the judges from the Social Security Administration, then they are appointed to be SEC judges. That they don't switch around.
No, I get it. Just in terms of their professional background and expertise, though.
Exactly.
Yeah.
Yeah.
So what happens next? The Supreme Court has agreed to hear this case?
Yes, and it was combined with a very similar case out of the Ninth Circuit. It's called Axon, and there is a claim under the Federal Trade Commission Act that these are also judges who are impermissibly insulated from removal under the executive branch. And so we are very excited that our case was granted cert. The court will hear separate arguments in the case because the FTC statute has its own scheme and the SEC statute has its own scheme. And as one of our amicus briefs argues, this is for the United States Chamber of Commerce, there's even a more compelling set of statutory reasons under the SEC Act why these proceedings are unlawful.
Wow. We're talking with Peggy Little, who is the Senior Litigation Counsel for the New Civil Liberties Alliance, NCLA.legal. It'd be one website where you can get there. I'm wondering, Peggy, are you going to have the opportunity to argue in front of the justices yourself?
Well, that would be great. We have had great help on this case from a Latham and Watkins partner, Greg Garr. He's a former Solicitor General of the United States. And so at the cert stage, we brought him in to assist with the petition. So he will argue the case. Will you be in the room? Oh, yeah. I'll be at the table.
Have you been at that table before?
I have.
What's it like being at that table?
Oh, it's so exciting. There's really nothing like it. And in my prior case, I won as well. So we're hoping for a good outcome. We think that the fact that the court has granted cert, both in the FTC action and the SEC action, means the court is very concerned about these unconstitutional adjudications. And in particular, the problem that you can't get to court until after the whole proceeding is done. And that is just plainly unjust.
Right.
You have to be able to get into a federal court to challenge the legality of the proceedings before they take place.
That makes perfect sense to me. All right, one more question about being at that table. Have you ever been at that table when Clarence Thomas asked a question?
No, I have not.
That's exceedingly rare, but maybe you will experience it this time. He's been a little more talkative lately, so we'll see.
Absolutely, and this is a topic that is and a subject matter that is very close to his concerns. So I hope he will ask questions.
I hope he will too. Peggy Little, Senior Litigation Counsel for the New Civil Liberties Alliance. We will keep in touch with you as the case proceeds, Peggy. Thanks so much for being here.
Thank you, Ross. It's good to be interviewed by someone who knows what he's talking about.